It's the Metro on WDET. I'm Robin Vincent. Here in Detroit, there's a straightforward rule on the books. A landlord can't rent a home until it's been inspected by the city. They need to prove it's safe to live in. But very few follow the law. Only 14% of the city's rentals are certified. Now, the Detroit Tenants Union, with support from legal groups around Detroit, has filed a lawsuit against the 36th District Court. They say the chief judge has failed to perform a clear legal duty. And that's because rulings in the court don't conform to the law, they say. They're not protecting tenants in ways they're instructed to. Professor Donovan McCarty is the director of the Michigan State University College of Law's Housing Justice Clinic. He's one of the lawyers representing the Detroit Tenants Union, and he's here to discuss the lawsuit. Professor McCarty, welcome to the Metro.
Thank you so much for having me.
And I do want to note, we reached out for comment from the 36th District Court. They have not yet responded to our request. So I got to ask you first, why did you file this lawsuit?
Yeah, we filed this lawsuit because it's basically exactly what you just said. It's a very clear ordinance that was passed by the city council. It's being enforced by BC. Even the law department under Mayor Sheffield is now stepping in to trying to enforce it. But where it's not being operationalized is the court. If landlords can keep going in to collect rent that's not lawfully collected, then they have no incentive to actually come into compliance, and that 14% number will not grow to where we need it to be.
Let's make this a little bit more concrete for folks, if we could. Could you give me an example of a case that would be affected by this?
Yeah, there would be thousands of cases likely affected by this. There are 13,000 non-payment cases that go through the court each year, 5,000 defaults, which is where people don't show up to their hearing, whether it's because they're not notified or because they couldn't miss work or whatever. But one specific case, and we have four people named in our complaint, but one specific declarant I think is a really good example. It's someone who came to his first hearing, didn't get notice of his second hearing. A default was entered at that point, and then he was told that he had to move out of his property. The landlord had no certificate of compliance. In our view, that case likely should have come out differently. It should have been reviewed to ask the landlord, do you have a certificate of compliance? If the answer is no, then there are 3 limited exceptions in the ordinance that the landlord could avail themselves of to continue to collect rent. But if they cannot prove that, because it's the plaintiff's burden to prove that, then they don't get to collect the rent, and that eviction never should have happened.
Okay, I want to try and make this even clearer for folks if we could. So let's say I am renting a home in Detroit. There are multiple things wrong with this home. I have plumbing issues. My roof is leaking. I have asked the landlord to correct these issues. They have not corrected them. And I have done my research, and I see that this landlord does not have a certificate of compliance.
Yeah.
They are not officially able to be renting this home in the city of Detroit.
Yes.
I stopped paying my rent because they are unlawfully trying to collect it from me.
Yes.
And then they try to evict me. And so I go and enter into proceedings at 36th District Court. And you are saying at that point, I should be relieved of any obligations. I shouldn't have to be paying my rent. Like, am I getting to an example of what this looks like?
Not exactly. This is obviously hard to deal in hypotheticals, but I will say that what we are asking for is the court to follow the review that is in the ordinance. And that review looks like there is a bar. It's unlawful to collect rent for a period of time you do not have a certificate of compliance. But that's not a strict bar. If you are a landlord that is trying to come into compliance and the building and safety department is not cooperating, not inspecting, not responding, if the tenant is in fact the one who's destroying the property, you can bring those things to court. You can show the judge, this is why I'm not able to comply. But if you're not able to do that, if you're not able to meet those exceptions, then yes, that rent is not lawfully collectible because of exactly the reasons you were just saying.
I mean, at the heart of this, it seems like the bigger issue is the fact that so few landlords are complying in the first place.
Absolutely. I think that's the difficulty in Detroit is we see mass noncompliance. If this was any other city, we would not have these kinds of numbers. But for whatever reason, we have in Detroit 86% of landlords refusing to comply with the certificate of compliance regime that would, and this is about the housing stock of the city, right?
It's old. It's crumbling.
It's old, exactly. But it's more than that, really. It's the fact that we haven't had this compliance. So we don't have landlords being inspected to say, you need to fix this, this, and this. So it keeps deteriorating generation after generation as it changes hands. And that's really what this is trying to protect. That's why the city council passed such a strong ordinance. That's why BC and the law department are trying to fix this. But again, the only place where this is not being operationalized is the court, and that's what we really need here.
Well, I want to think about that, the 36th District Court here, because you have to work with that court a lot in order to properly represent your clients. I mean, do you worry that because of this lawsuit, you're potentially fraying your relationship with the court and that it could therefore create negative consequences for your clients?
Honestly, yes, I do worry about that.
Yeah?
Of course I worry about that. We've tried to communicate with the court. We tried to have a meeting. We had a meeting scheduled that was canceled. We are still open to a meeting. We've said that over and over again. I want to communicate about this. We didn't want to file this lawsuit, but we were not given our clients needed this lawsuit filed because they were not being heard. Do I worry about it fraying my relationship? Sure. I used to do a lot of work in the eviction defense in 36th District Court. Now I'm not just doing that, so I'm worried a little bit less about it. But I do want to protect tenants, and I would hope that the court would understand that and not see this as a reason to be, to take retribution out on my clients or any other tenants in the city for just trying to enforce the law, which is literally all we're doing. If you read it, it's crystal clear.
It's the Metro on WDET. I'm Robin Vincent. My guest is Donovan McCarty. He's the director of a housing justice clinic with Michigan State University's law school and one of the lawyers representing the Detroit Tenants Union. We're discussing a lawsuit he filed last week against the 36th District Court for not following a Detroit law, which is meant to protect tenants. So, again, I want to go back to the bigger problem at hand here, because for decades, Detroit has had this same law on the books. A landlord can't rent you a home until the city has inspected it and proven it's safe to live in. And we know that almost nobody is following it. Landlords say things are made too hard for them to get a certificate of compliance. I recently spoke with outlier reporter Aaron Mondry. He's done a lot of work on this issue, and he, of course, came from both sides of things. And I want to listen to him speaking from the landlord's perspective right now.
It's hard to run a profitable rental business in Detroit when the maximum rent you can earn is not very high and may barely cover your costs. And then on top of that, you have bureaucratic costs imposed by the city. So yes, this is a challenge. And earnest landlords who want to comply, who want to provide safe housing, say that this law is overly burdensome to them and that the city needs to make it easier.
What do you make of the landlord's perspective that it's too hard to certify their property and that the 36th District Court is being considerate of those circumstances?
I think in very few circumstances that's absolutely true, that there are quote unquote good landlords that are just trying to follow the law and are being stymied, right? Maybe BC isn't able to inspect, maybe they don't respond, all of that. But we're looking at a number of 86%. We're looking at 70% that haven't even registered with the city. That's a 20-minute process online. So to characterize it in that way, I think, is a mischaracterization. It might be difficult in some cases, but frankly, I have it on good authority that the Building and Safety Department is ready and willing to accept anyone who comes to them to get inspected for a certificate of compliance. And that's really all we're asking, is for them to do it. It is not, I can't practice law without a law license, right? As my co-counsel Ben Christensen always says, a speakeasy cannot go into court and try to collect bar tabs. If you're not licensed, you cannot operate. the way lawfully, right? And the court should not enforce that. So I think that it might be challenging in some circumstances, but I also think that on the whole, we're looking at 86% of landlords not complying.
I want to dig in a little bit deeper to something you said, which is that you feel there are very few circumstances here where this is a situation that a landlord is genuinely trying to do what is right. Am I getting that?
Basically, I mean, what I'm saying is if that is the case, then the protections are there in the ordinance. All we're asking is for the judge to review that. And if you can say, I sent an email on this date, BC didn't respond, or I have proof that my tenant was destroying the property or didn't let BC in, go to court. Show that. You'll be able to collect rent. But I think the fear really is that those things are not happening, that 86% are not doing that, and that they will not be able to collect rent.
And what are you seeing, I'm wondering, within this world of housing justice that you're deeply immersed in that gives you the kind of confidence that you have right now, or I guess I should say, the kind of unfavorable view that you have right now toward a lot of these landlords that are not in compliance? What are you seeing?
Yeah, I mean, what I see is, lead, right? We have elevated levels of lead in the city of Detroit, mold, pests, plumbing, not even to bathrooms. So people are bailing out their bathtubs. I mean, no electricity, no heat in the winter, so you have to use space heater. It's not safe. And I think that also gets to the piece. We often talk about the landlord's financial cost. What about the tenants, right? What about the fact that there are children being poisoned that have to live with that consequence for the rest of their lives? Their families live with that consequence for the rest of their lives. That is the financial cost, a real cost. So to say, oh, you're getting rent free, that's not the truth. The truth is you're being made to live in substandards, inhuman conditions.
The 36th District Court has shown quite an interest in trying to give tenants a leg up. I mean, I'm thinking about the legal representation that they provide to tenants for free. That seems to be a crucial program that has made such a difference.
Absolutely. But I will tell you this. I have had countless tenants come to me and say, you're never going to believe this. My landlord doesn't have a certificate of compliance, thinking that it's going to impact their case in any way. And up until this point, it has not. I have to tell them, unfortunately, yes, you can read the law the same as I can, but the court is not going to enforce it in the way that it should be.
When you talk about enforcement, what do you make of the perspective that it's ultimately the city of Detroit's fault for not enforcing the certificate of compliance?
I'm really not here to place blame. I'm just here to say everyone has a role in this, right? We have a role as attorneys. BSeed has a role. City Council passed this ordinance. BSeed, I've seen countless times where they've said you need a certificate of compliance, and they've ticketed people for it over and over and over again. The city law department now is targeting 61 buildings that are in routine noncompliance. Where, again, this is not operationalized is the court. So we just want them to play their role. And frankly, in other dockets, not on the landlord-tenant docket, but if you read our complaint, when a landlord comes to try to collect in small claims or general civil, the judge is dismissing those cases sua sponte, meaning on their own. A defendant doesn't even show up. Those cases are being dismissed. Why? Because they don't have a certificate of compliance. Why is it that the one docket that this could be operationalized and affect thousands, tens of thousands of Detroiters is the landlord-tenant docket?
Donovan, you're ultimately hoping that a higher court, the Wayne County Third Circuit Court, ensures that the 36th District Court is enforcing the law that renters don't have to pay money to a landlord until their property is in compliance. If this goes well, what will they be doing to ensure the 36th District Court enforces the law in the last minute we have?
Yeah, so our goal is to have an administrative order issued, which is basically an order that would simply say, judges, when you're given a case, right, you have to ask, do you have a certificate of compliance for the time you're trying to collect rent? If not, then review those three exceptions. If there is one of those exceptions that is met, proceed, allow them to collect the rent. If not, dismiss the case. That is the clear review in the ordinance, and that's all we're asking for. We're not asking for anything magical or beyond that.
Donovan McCarty, he's the director of a housing justice clinic with Michigan State University's law school and one of the attorneys representing the Detroit Tenants Union. Professor McCarty, thanks so much for joining us.
Thank you very much.
It's the Metro on WDET. Coming up, many eyes are on the World Cup, but the Wimbledon tennis tournament is going on in England right now, too. We'll talk about what it means to be both a mother and a competitive athlete in that tournament now. This is WDET-FM, Detroit Public Radio, your connection to news, music, and conversation. And this is the Metro. We'll be right back after the news.